Well, okay, it is 6:35. I know it's important for everybody to stick to the schedule, and we try really hard on these calls, as I always say, to stick within the time frame given. Folks are busy, and this is a very educational, but it's there's a lot of competition for our time in our lives right now. So even though we have kind of a small number online, I think I am going to introduce our speaker and let him kick it off. And as people join, then that'll be okay. This is the fifth in the series that we've done on topics that are of interest to small developers. And we did a few months ago talk to Linda Carter about Real Estate 101, but that was more from a real estate agent's perspective. And of course, we also talked to Sharon Simmons in our kickoff call, who's an attorney, but again, she's more of a business attorney and she's based in Texas. So Bruce is sort of the best of both worlds in this case, because not only is he an attorney who knows all about real estate, he's also a local attorney who knows all about real estate and real estate transactions and real estate law. And he knows South Bend in and out and lives here and has worked here for many years. So we're grateful that he's willing to share his time with us tonight. He also is an educator himself. He's taught at IUSB for many years. And so he knows how to communicate information to a crowd. He's going to try to condense a semester's worth of work into 40 minutes. So it's going to be magic. Bruce, I'll hand it over to you and you can introduce yourself more appropriately and tell us about yourself. And
okay, well, thank you, Marty. It's my pleasure to be here tonight. I've been involved peripherally, having attended a meeting over at the Hungarian Church, Our Lady of Hungary Church.
Yep.
And I'm impressed with the group that really wants to get this done, that has the drive and ambition and insight to do the kinds of things that the small development group is trying to accomplish. And there's lots of opportunity. And you should find that opportunity to take advantage of it. What I want to talk to you about tonight is basically the fundamentals of the law and kind of attach them to real estate so that we kind of focus a little bit on what are the basic elements of law, what are the basic elements of contract and things like that. And I will try to do that. I will leave this open for questions later on, and also I will leave contact. If you want to call me and talk to me a little bit about this, I will not charge you for that phone call. And as long as you keep it within a reasonable amount of time, I'm happy to talk to you about what your questions are and what to do. What I have done is compressed what is essentially a semester-long course in my class notes down to about 40 minutes. And so I'll be speaking I'll talk fast like those guys on the mortgage ads that do not understand what they say. I will leave it open for questions, as I said, and your thoughtful questions are invited as we go along here. When I first got into the real estate business, I had a couple of mentors that were very good people that helped me understand what I do and why I do the business of real estate. And one thing that was given to me that has stuck with me for a long time is the statement that under all is the land. We start with the land. Well, those of us who are engaged in the real estate business understand that pretty intimately. Everything happens with the land. It's the foundation of our economy, and it's the foundation of any economy, if you think about it for a minute. Virtually all value, as we generally define value, is basically based on our efficient employment of land resources and principally as private entrepreneurial parties. We undertake this on a self-motivated, discretionary private act that leads to our own benefit. Well, that sounds like capitalism to me, and I am a capitalist. I've learned to be that. When I was a young kid in college, my dad thought for sure I was a communist, but he was wrong. But in the 1960s and 70s, weren't we all? one of the things that I think about when I think about what we do with real estate, if you think, virtually everything we do, every function we have, whether we are farming, whether we have a city, if we're doing housing, industry, transportation, extraction, especially if we're taking coal or iron ore or minerals and water out of the ground, that's all related to the land. And so the land is everything. We are connected in a million ways to the earth and to the land, and everything starts at that point. We call our efforts at the improvement of the land real estate. Real estate is a legal term, essentially, that differentiates the land and what we do with the land from everything else we do, which is called chattel. Anything else that we do, anything that's unrelated to land, that's not land related, or not land itself, is called chattel. And so we are connected. Real estate establishes a legal ownership and a possessory right to keep and hold a parcel of land for our own purposes. It's ours. We have the fee simple interest. You've heard that term before. I'm sure of that. Questions I get asked a lot is how, in seminars like this, is what's the best way to get real estate? So what's the most common means by which we can acquire real estate? Well, if you have a rich grandmother, a rich uncle, inheritance is a really good way to go. But few of us have that. But it happens a lot that inheritance is a good way to go. Inheritance goes, of course, to heirs. But another way to do it is to have a rich friend who will leave you his farm or his office building or something. That's called devise, D-E-V-I-S-E, devise. That's when it's given to you, but you're not a relative. Most common way we do it is with acquisition and purchase. We buy the property, and it's just how we do it. I've been involved in, over the years, in literally hundreds of land-related transactions and acquisitions, and most of those have to do with purchase and financing and all of that. So our typical best way to do it, is always through a purchase, and many of you have done that already, are involved in sales and transactions for purchase, so you understand we buy the property. The most uncommon way for us to acquire land is through something called adverse possession. We can establish an adverse possessory interest in the property by simply using it, sitting on it, acquiring it, using it, and using it for a lengthy period of time on a notorious and open basis. Indiana, however, has sort of done away with adverse possession. So those of you who think you might acquire your neighbor's land by simply mowing it, probably doesn't work anymore here in Indiana, because Indiana now requires you, in order to enforce an adverse possessory claim, you've got to pay the taxes on the property. And that's hard to do given the way our recording system works and just the way the assessment of land works. It's very difficult now to do an adverse possessory kind of claim. And so I haven't seen that now for many years with anyone trying to create an adverse possessory claim. So what's the first step? What do we have to do when we start this? Well, usually we start with a contract to purchase, and you've heard about contracts to purchase, and I'm going to give you the general overview of contract law, what we have to do when it comes to forming a contract. Now, you've all seen the real estate practice forms, the MLS forms, and those generalized forms that are forms. I don't do forms. Everything that I craft for my clients is usually customized for their particular need in creating the transaction that they want. And so the form follows function. And so when I know what the function is of the transaction itself and of the parties, I literally tailor the contract to that particular transaction. But in large part, most of the same things will apply when it comes to that. And we'll talk about those a little bit. Here's some critical elements of contract law, okay? First thing you have to have is something called mutual assent. Well, mutual assent is best shown by an offer to purchase and an acceptance. Offer and acceptance are the two principal elements that lead us to the formation of the contract. And these three elements that I'm telling you about are required. Mutual assent. Mutual assent means that everybody knows everything about the transaction. The parties, the buyer party and the seller party knows everything they need to know. They have complete knowledge about the transaction. If we don't have complete knowledge about the transaction, or something's hidden from us, that contract can be charged with fraud. And you don't want to do that. Always be totally open about everything that you do as a seller or as a buyer. I'll give you a good example of where some fraudulent transactions happened, and that was when Disney bought up all of Florida. They went out there without revealing who they were. They had shell companies, and they had straw companies that were going out buying up the land because they didn't want to create a rush that showed prices shooting through the roof when Disney bought all that land. And when people found out that it was in fact Disney, they were a little bit angered by the fact that they sold too cheap early on. So disclose everything in a transaction that you're undertaking. We have offer and acceptance. I mentioned that when you have this transaction, the offer and acceptance, the acceptance has to be the exact same mirror image of the offer. And if you don't have the exact mirror image of the offer, and you give an offer, you make a change in that you change the offer in your acceptance, that's called a counter offer. And you're all familiar with the concept of a counter offer. Be careful with counter offers. At some point, you should stop and start all over again. One or two transactions back and forth, or negotiations back and forth. That's the best way to do it. Don't overdo the back and forth and back and forth and back and forth. Just start over again. Rewrite the contract and start with a new offer and new acceptance. The third fundamental element of contract law is something called consideration. If you read a deed, the deeds always recite consideration. It will say something like, for and in consideration of the sum of $1 and other good and valuable consideration. I always add the receipt and sufficiency of which is hereby acknowledged. That goes into my contracts, that goes into the deeds that I draft. Consideration it's a strange concept, but it's essentially the bargained for exchange of the transaction. I give something and you give something. I get something and you get something. Okay, if I'm buying your piece of real estate from you, I'm going to get a deed for the real estate. What I'm going to give up for that is money, or cows, or cars, or another building, a swap, a different piece of land. That consideration is this mutual benefit that extends back and forth between us. Consideration is essential. It's the point where contracts fail the most. Failure of consideration. And I'm getting ready to try a case right now that I'm going to win, because the issue that comes down entirely is, what did these parties pay my client for the real estate? And it's a bogus, fraudulent transaction. And I have tried to convince them to walk away and just close out the deal and be done. But consideration is essential. And if you win or lose a case, it can often hinge on consideration, this bargain for exchange. Another thing you have to have is no defense to the formation of the contract. No defenses. It can't be an illegal contract. It can't be a contract formed by infants, someone who's under the age of, say, 18. It can't be a void contract. Contracts that have some element that is essentially void. The real estate doesn't exist, for example, that you're trying to, that would be a void, or even a fraudulent kind of transaction. Those are all elements that are defenses to formation. And another one that's very important that you should know about is something called the Statute of Frauds. Statute of Frauds is confusing, but it implies essentially that there are 6 important parts of the law that are so important that any transaction involving them has to be in writing. And of those, the acronym is my legs. It stands for marriage, a contract that cannot be performed within a year. Think about that in terms of leasing. Anything to do with land, anything that has to do with the land has to be in writing to be enforceable. And I'm talking about listing contracts, sales agreements, deeds, contracting agreements. All of that stuff should be in writing and must be in writing in order to be enforceable. And so when you think about hiring a contractor or having some work done, you make sure that guy has a contract that complies with the law so that you're not out there stuck without it. The Statute of Frauds requires a writing anytime you're doing anything with regard to real estate. So bear that in mind. Well, if we're going to acquire a piece of property, what should we do? What steps should we take in doing it? Well, the first thing is define what your needs are. What do I want? What is my expected use of this property? What are the land uses that I have in mind? Will it be something like housing? Will it be industrial? Will it be commercial? These are the things that you have to identify as you go. You know, you don't just go out and buy a piece of property necessarily because it's right there, unless you're speculating. And I've done that myself. I've done it pretty well on a couple of occasions, and I have been burned on a couple of occasions. Nothing speaks like experience, and I caution you to be careful when it comes to speculation. Know what you're buying and know why you're buying it. That's kind of critical. So you should first step, locate a legally permissible parcel of land given your expected needs. You want to know about site conditions. You want to know about the nature of the terrain. You want to know what's underground. Just outside our office the other day, we have a piece of parcel or a piece of land that appears to be being sold, and we had surveyors and drillers out there drilling holes for probably issues related to what might lie underneath. But that's a step that's important to take to know what subterranean conditions are and all of that. Know what's going on. So find a good piece of land. The next step is be open about this and contact the owner. Tell them what you want to do, what you want to buy. Just Monday, I got a phone call from an appraisal client of mine. And that's a point I should make. I'm also a state certified general appraiser with about 40 years of experience doing general commercial appraisal work. But I had a client call me and said that he had two people all of a sudden approach him about the sale of his apartment buildings. He has about 160 units, I think, in a small town nearby. And he was approached by two people wanting to do that. They came directly to him. There's no real estate agent or anyone involved, but both parties, independently, unknown to each other, came to talk to him about selling his property. And I think it's worth it. But the owners can be anybody. It can be an individual, like in this instance. It can be a corporation. Well, you can find out who's at the base of a corporation by going online to the Secretary of State, logging into the business services part of that. Just click on it, and you can find out by searching out the name of the company who owns something. You can also find out using here locally a very good tool that we have, which is the MACOG GIS system. We can find ownership pretty simply using that system for both Elkhart and St. Joseph County. In Marshall County, used what's called the Beacon system. These are great information system tools that you can use to find the property owner and then approach them. You should negotiate for your mutual benefit. When you are trying to put together a transaction for the purchase, if you want to acquire something, or if you want to sell something even, you should negotiate for the mutual benefit of the parties. If you start from that position, and it's not all about you trying to garner in as much as you can, play fair. You get a lot more done playing fair and being reasonable with the other side. If you simply negotiate for the mutual benefit of the parties and consider terms and conditions, do all that first. Think about price second. Okay, don't worry about the price. Worry about putting the deal together first. What's it going to take? And then find out what the price has to be. And literally, if you start with the price, you're log jammed. You've got to have other consideration within the transaction other than just price. So back up through the transaction, do the price negotiations last. You should know a little bit about the title to the property. Who owns it? Is this person selling it the owner? Is that person competent to sell the property? I had a case many years ago where my client was approached to sell the property. The deal was going to be pretty good. They signed the contract, put the whole thing together, unbeknownst to family members, and certainly not, I wasn't told about it. And it turned out that the party that was signing the documents for the sale was under a guardianship and was legally incompetent to enter into that transaction. So know who you're dealing with. Find out who's got the right to sell, who's got the ownership, who owns title to the land. That's critical. Most of you are familiar with the concept of a title search. You can do your own. I don't recommend it. We have some very good title companies in the area that any one of whom I would recommend, and certainly always recommend a title company to help you determine who owns the property and what are the conditions that might be affecting it in terms of the quality and integrity of the title that you will be buying. You want to know about things like utility, the function of the property. What can I do with this? That would be a zoning issue, wouldn't it? What are the limitations? Are there restrictive covenants on the land? I came across a case several years ago where they wanted to do a subdivision and they wanted to have a clubhouse, and the clubhouse were intended to serve alcohol. Were attached to a golf course, of course. And it turned out that the people who owned the land had the grandmother had given it to a grandson or through the property, but the deed to the grandson contained a provision that no alcohol would be served on the property. How do you overcome that if you want to have a bar in your golf course? It says no alcohol for so long as no alcohol, and if it's served, then the property would revert back to grandmother's estate to be distributed otherwise. You need to know about the covenants. You need to know about what the deed restrictions are, and that's why a title search is essential. Don't buy a piece of property if you don't know the condition and limitations of title. Absolutely essential. I don't touch anything before I know what the title condition is. First, you want to buy a piece of property, I said, bring me the title report first, and we'll see what we can do. Because as I draft a contract for the purchase of that property, I need to know what the conditions are that might affect you as my client. You've probably learned a bit from the real estate agents who have taught you about what goes into a real estate purchase contract. And it's pretty simple. This is general stuff that goes in, it should go into any contract when it comes, when you're buying something or selling something. The first fundamental thing you should do with a real estate purchase contract is identify the parties. Who's on first? Who's playing here? Who's doing it? Who are we dealing with here? Who are the parties? Identify the parties clearly and know you get that information in terms of ownership through the title work that you would have done. Second thing you want to know about is the property. What is the property? How is it described? We have many ways to describe property. We have the lot and block, lot 1, or lot 325 Sunnymead First Edition. You know, we know what that is. We know where to find it. We know what it looks like because we have a plat to refer to. We could also have a meets and bounds description, which describes the bearings and departures and distances and lengths and things like that run typically clockwise around from the beginning point all the way around. And if you start thinking about those and angles, you can figure out how to do those, read those, and figure out what's there on your own. Again, you have to recite in this transaction, in this contract, you have to recite the consideration. I have here in my notes, recitation of consideration with exclamation points. What's the price? What are we buying for? What are we buying? How much are we paying for what we're buying? And what is the consideration? Well, maybe the consideration is something other than money. Maybe we're trading a piece of property. Maybe we're trading an automobile or 2 automobiles. Maybe we're selling our children. I tried that, it didn't work, they came home. They always do. Leaving them out in the country, you know, they always found their way home. It just seemed to work. But the consideration is remember we talked about consideration, it's mutual exchange. Recite the consideration in the contract itself. Always, always, always. And then in drafting your contract and putting things together, discuss and describe and include the limitations of the transaction, what restrictions you have, what additions you might make, and what the duties and obligations of the parties are. I always put the duty section in there that shows the duties prior to closing, the duties to get to closing of the seller and of the buyer. I want to know who has to do what and when, because that forms the path to closing. And that's where we want to go, is to closing when we have this transaction put together. We want to just determine what the expectation of performance of the parties are, okay? Because a contract will fail on failure of performance. If you don't do what you promised to do, or the other side doesn't do what they promised to do, contract can fail for lack of performance. And I won't get into the details of all the things that can happen. You'd have to come take my course at IU or go to law school in order to get all that. And you would be welcome to come take the course at IU. Then you draft the contract. You've determined all the things you want to go in the contract, then you sit down and draft it. And this is where it gets difficult. You have to be careful when you're putting the contract together. And most of you will use a form type contract that does some of these things already. But I can tell you, when I craft a contract for purchase of real estate, I start out with paragraph 1. And then I will draft paragraph 2. And I read paragraph 2 and I look back at paragraph 1 and say, is there any conflict here? Is there ambiguity in this transaction? Is it confusing somehow? Could a reader confuse the language in this somehow? I use the example in my class of the phrase eats, shoots, and leaves. Now we're picturing some kid walking into McDonald's with a handgun, gets a cheeseburger and runs away, shoots his rifle or his handgun and walks out the store, eats, shoots, and leaves. In fact, that would describe a panda, wouldn't it? You've probably heard that before. Language is important. How we write it, what we say, the language that we have. And ambiguity will kill the transaction. Be very careful about what you write. Again, paragraph 1 determines what goes into paragraph 2, but paragraph 2 determines whether or not I keep paragraph 1 as it's in its form. Paragraph 3 goes to 2 and 1. Paragraph 4 goes to 3, 2, and 1. And keep that in mind as you do that. Form contracts are helpful in that that's already been done for you. The lawyers who draft the form contracts that the MLS and others use are pretty good. And sometimes I will steal the language out of one of those if I think that particular paragraph or particular phrase is good. Cite the parties, the price, the consideration, limitations to use. Also, sometimes you buy non-real estate assets for the transaction. You sell a piece of property and it's got some equipment on it, perhaps. You must cite and identify the owner of that equipment if you're going to either buying it or selling it. Know who owns that equipment, because even though that may be included within the transaction itself, that's chattel, and that's separate and apart from the transaction for real estate, even though it can be incorporated in the transaction. Again, when it comes to title, the most important thing about the title that you are going to get or give is that it is marketable title. Marketable title is essential to this sales transaction. When you buy something, you want to have it marketable. And when you sell something, it better be marketable, or you may well be charged with fraud. You need to know what's going on. You want to know what estate are you getting? What tenancy are you getting? Are you getting the fee simple estate? If you're familiar with real estate at all, you know what the fee simple estate is. You've been there and seen it. Fee simple is absolute. That's the best you can get. It's unencumbered and it's yours, free and clear. You want to know what estate you're taking or giving. If you take a piece of property, you want to know by what tenancy, and you're familiar with this. If Marty and I and Barbara here buy a piece of real estate together, we want to know how we're going to hold that. We are unrelated parties. And I happen to have Marty in the left corner and Barbara is next to me on the other side here. If we're going to buy a piece of property together, how are we going to own it? Well, generally for that kind of transaction, we would own it as tenants in common. And what's important about tenants in common is that your ownership stays with your estate, and you can divide it up any way you want. You can have 20 parties, you can have 3 parties. In this instance, if we bought that property together, we would each have a 33 1/3 interest in the property, unless I put in 50% and Marty and Barbara put in 25%. We can do that with a tenancy in common. But what happens with a tenancy in common is it sticks to you. If you die, your interest does not go to your co-owners. Your interest goes to your estate. And that's important to know when you buy a piece of property, who you're dealing with and who your partners are, because guess what? If I die, Marty and Barbara are going to get a whole bunch of new partners who will own that real estate with them. Be careful about how you do that. I dealt with this recently in a sale of a business. A transaction involved poorly recited information in the contract, in the initial ownership, the initial partnership agreement, actually. One of the partners died, and it went to his ne'er-do-well son. And the ne'er-do-well son now became the partner of these 2 people who had worked all their lives to run this business. And they ended up paying him more than it was worth to get rid of him in order to maintain the business. So know who you're dealing with when you get to that. Another form of tenancy is something called joint tenancy with rights of survivorship. Same scenario. Marty and I and Barbara buy this property together. And we own it as joint tenants with rights of survivorship. This is what I call the last dog standing situation. If I die, now Marty and Barbara own the property together as joint tenants. Not as tenants in common, as joint tenants. They could transfer it. They could make it a tenancy in common, but if it remains as a tenancy, a joint tenancy, either one of them die, then that property goes to the survivor. That's why it's a survivorship type of ownership. And be careful. Siblings perhaps can do a joint tenancy kind of thing. My brother and sister and I actually own my mom's house but my mom is now 97 years old and hanging in there, and she still gives me the devil like when I was a teenager. We own that property as joint tenants, so one of us goes, the rest of us own it, and that's kind of appropriate for siblings. Another way to own it is to let's say Barbara and I are blissfully married together. Okay, you didn't expect that, did you, Barbara? We are happily married. Look at her smile. She's happy. Okay, we're happily married. Okay, we own that property in a form of joint tenancy called the entireties. That's important to know. It's the entireties, and what essentially happens is, in the entireties ownership, is that the marriage owns the property. But if the marriage ends by virtue of a death, automatically the surviving party, it goes to the surviving party. Except where there may be a pending divorce. And I have that going on right now. The wife died in the process of the divorce. Husband has a claim to the real estate. And that upsets siblings of the wife who's dying, who intended to put this in their name as a joint tenancy. So you can see some of the troubles that happen. If Barbara and I own the property together and I go first, Barbara is going to own this property. She's going to sell it. She's going to move to Florida, buy a big boat, and live happily ever after with some young crew member or something. Good luck, Barbara. The ownership, the title, how you take the tenancies are important. Now, let's talk a little bit about something called conveyance. Conveyance is a transfer of property. Conveyance is how we move the property from our own ownership into the ownership of somebody else. And the way we are most commonly doing that is through something called a deed, a document that's called a deed. In merry old England, a deed was, until the Statute of Frauds came along in about the 1650s, the way you transferred a piece of real estate, you would take the buyer, or the prospective owner, you would stand on the land and you would describe the property to them. And it would be something like, well, it starts at that tree and then it runs to that big rock and then it comes over to this elm tree and it goes back over to this rock and back to the original tree. And that was a description. We still do that, but we have points in surveys now to do that. But that's how we did it in Merritt Old England. We would tell the person where the boundaries of the property were as best we could. The way we made the transaction happen, though, was we would reach down, pick up a handful of dirt, and place it in the hand of our buyer. That was the deed of conveyance. The act of conveyance was that deed, and the deed became then a written document that was essential after the inception of the Statute of Frauds, where the deed had to be in writing. I have back in my office in my home, I have a deed from 1795 in Massachusetts, where Charles Clark gave a piece of land to another individual, and in the document, Charles' wife Hannah had what were called back then dower rights, which is the same thing we have now as entireties rights. She had a right to the property. She had no ownership interest. She had an interest on death, on Charles' death. And so in making a transfer, she didn't sign the deed to transfer the property from Charles to his buyer. She signed basically a verification of her surrender of her dower rights. Okay. So we do, and if you read the deed, it looks like every other deed we do these days. The habening clause and all the clauses of the description and all that is the same. So we've been doing this for a long time, the way we do it with the transfer of deeds. Okay. The contract will tell us how to convey the property with a deed, with a bill of sale when it comes to chattel properties. Okay. Sometimes we do these things called land contracts. If I could see all these faces on screen here, I would ask you to raise your hand about how many of you have done a land contract and how many of you should be punished for doing that. Okay, don't do land contracts anymore. Indiana, since 1973, has changed the whole context of property owned by or transferred by a land contract. The issue now is that I try to do with my land contract wannabes is to do something called a purchase money mortgage. And a purchase money mortgage is essentially what it sounds like. Whatever the money for purchase is, whatever the balance other than cash that's coming in, you as the seller finance that and essentially become the bank. And you take a promissory note, you take a mortgage that describes the property, and you essentially stand in the shoes of a banker. You become the banker. And the reason for that is that since 1973, in what was called the Skensel case, the idea is that you as a land contract buyer build an equitable interest in the property. And the old time land contracts that you could go for 20 years, pay every month, be it month number 239 and be late with a payment or breach the contract somehow, you lost the property as the buyer because there was no establishment of equitable interest. And that Indiana did away with that just in 1973. What is that, 50 years ago? They did away with that contract, that provision of contract. So now the courts will look at a land contract and say, hey, you have to foreclose this land contract. You can't forfeit. And forfeiture is pretty much out the window now. No judge, with very rare circumstances, no judge will allow a forfeiture where there's been a lengthy period of ownership. And there's no hard and fast rule about what the percentage of ownership is or percentage of equity that you have. It's just simply, it is simply that issue of your equitable interest as a land contract buyer. And it establishes pretty much the same way, along the same lines as an amortization schedule would. Your interest increases as your mortgage reduces. And that's the way it is with when we have a mortgage on our homes. We get better every month when we reduce the principal somehow. So purchase money mortgage is the way you should go if you're thinking about any kind of self-financing. When we do this contract that we're preparing now, The other thing we want to know is know what the financing is going to be, whether you're the buyer or the seller. Have your financing in place, or make sure that your buyer knows what he's doing in terms of the financing. Don't make commitments where there's an unfinanced transaction. You want to make sure that that's covered, and know what the source of those funds are. You don't want to do a deal for drug money, okay? You want to do a deal for free and clear or happy cash. Talk a little bit here about security interest in real estate. Security interest in real estate. A banker gets a security interest in the real estate with a mortgage. If you're selling, you can get it with a land contract. In Texas, they do something called a deed of trust, but it's the same thing where the lender is involved and the deed is given over, but it's a deed in trust held by somebody. When you get to closing, what are the conditions of closing? You want to know what that's going to be in the contract. Identify those clearly, the terms and conditions to get to closing. You need to do that. And then when it's all said and done, as if you're the buyer, walk your deed immediately to the recorder's office and put it of record. Don't wait, don't hesitate, don't say I'll do this in a month. Do it that day if you can. If you close downtown, walk it to the county city building, take it to the auditor take it to the assessor first, they'll initial it, then you take it to the auditor on the second floor. They will charge you $10 for that. Then you take it to the recorder, and whatever the fee is for recording these days, put it of record. And the idea of record is it gives constructive notice to everybody in the world about the fact that you own that property, and whatever conditions of mortgage may follow it. You go first. Get that property in the record immediately. Do not hesitate. You want to get it done. Let's talk a little bit about landlord-tenant issues here, and we'll try to get through it. Landlord-tenant relationship. You should never do a tenant relationship with a handshake. Okay, do it with a lease. There are lots of good leases out there. You can find at least something in the stationery stores, like Office Depot and something like that. You at least use that. Find something that's a lease that lays out the obligations of both sides. I have several apartment complexes. They're clients of mine, and I help them with their leases. And some of the lease addendums are greater or bigger than the lease itself. So know that a writing is important. Remember, it's a lease. The statute of frauds will apply if it runs for more than a year. If it cannot be satisfied in a year, it needs to be in writing. You should know a little bit about the tenancies. We talked about the tenancies. In leasehold tenancies, there's a tenancy for years. There can be a periodic tenancy, which would be 1 year or less. There are tenancies at will and tenancies at sufferance and holdover tenancies and things like that. Leases are just another contract, okay? And your lease should be in writing. It should never be on a handshake basis. Just get it done. And again, just like any other document, the elements of a lease would be identifying the parties, identify not just who the tenants are. The tenants are the people who sign the lease. They are obliged, but know who's going to live there. I just finished a case for one of my apartment complex owners. The guy who was the tenant signed on the lease. He owned it, owned the lease. He was the tenant. Had some medical issues and went to the hospital and was tied up for many months in the hospital. Continued to pay the rent, but his friends moved into the apartment, and his friends were using drugs and gambling and prostitution and all kinds of things in a relatively nice apartment complex. They were not tenants, were they? They were trespassers. They were occupants. And so know in writing who the occupants are going to be, who the tenants are going to be. A tenant would be mom, and the occupants would be her kids. Okay. Tenants should be mom and dad and their kids. They will be the occupants, but know that you do that. Okay. What are the tenant's duties? The tenant can't waste the property. They have to use a legal use. You can't use the property for illegal purposes, and they got to pay the rent. And the landlord remedy is you evict if they don't pay the rent. Landlord duties, what is the duty of the landlord? This is a little bit less. You've got to deliver possession of the property. Your tenant is entitled to what's called quiet enjoyment of the premises. Quiet enjoyment doesn't mean that the landlord makes sure that your adjoining tenant or your upstairs tenant isn't playing his stereo too loud. That's not the obligation of the landlord, and it is not an issue with regard to quiet enjoyment. Quiet enjoyment means that your landlord is not trespassing your lease or going into your property and troubling you or doing anything. I had a case some years ago where I had two young women who had rented an apartment together, and they discovered that things were disturbed in their apartment. And so they put a baby monitor in that recorded somehow, and the baby monitor caught the landlord basically trespassing the drawers of the in the bedrooms. He had no business doing that, not at all. And we got out of that transaction confronted. We got a whole year's free rent for my clients for that guy's trespass. He violated the premise of quiet enjoyment. Okay, can't do that. Just don't do it. And that's why sometimes in a lease you'll see a provision 24 hours notice to go in and change the light bulbs or change the filter in the furnace. They're allowed to do that as a landlord, but they have to give you notice so as to avoid the claim of breach of quiet enjoyment. The other thing a landlord has to do is give an implied warranty of habitability. I can live in this house. Many years ago, I had a case where a guy bought the house, he bought a unit or rented a unit, moved in, the water heater was not connected, the water was not connected, the toilets wouldn't flush, the gas was not connected, so he couldn't keep it warm, and wanted out of the lease after a down payment of some thousands of dollars of upfront money. It was not a problem getting him out as soon as we pointed out to the landlord that you have an implied warrant of habitability. He can't live in a house that doesn't have this. So as a landlord, you have that obligation. And I'll go quickly through some of the rest of my notes here so we have some time. What I want to talk to you about is when we talk about deeds and types of deeds, you're all familiar with a quitclaim deed. Okay, I can give you a quitclaim deed to that office building where Marty is sitting. I can give you that quitclaim deed. I can sign that over, give you a notarized quitclaim deed, quitclaims all of my right, title, and interest in that, and hand it to you and take your money for it. Okay. The question you want to ask is, wait a minute, Professor, do you own that building? Do you have the right to sell that property? Is that yours? So a quitclaim deed does nothing more than give the interest of that seller, that grantor, to the extent of whatever that interest is. That's it. Don't take quitclaim deeds. Okay. And you should not be giving them either. Okay. But these transactions happen all the time, much to my chagrin. Your general warranty deed, the thing that you should be giving, is superior. And I'll give you these short elements of a warranty deed. When you give a warranty deed, here are the warranties that you're giving. First, that you own it, that you have the right to sell it. You have both title and possession. That's called season, or S-E-I-S-E-I-S-I-N, season. Grantor has both title and possession. Coupled to that is the right to sell it. You have a right to convey it. You may own it, but maybe your contract with Aunt Martha says you can't sell it until, or for some purpose. You have to have the authority to transfer the property. And if you have title to the property, a deed, that will satisfy the requirement. You have a covenant against encumbrances. That means you're selling it free and clear. There's no encumbrance except as may be accepted by the seller or by the buyer. That's a covenant against encumbrances. Again, a covenant of quiet enjoyment is something you put in your warranty deed. That means that nobody's going to come forth. No, if someone comes from two sales ago and says, no, I have a title interest in this property because my Aunt Martha gave it to me with this deed, and he shows you the deed, you are guaranteeing that person is not going to be there. And candidly, that's about the only reason we buy title insurance, to insure ourselves against the unknown. Okay, know that. Warranty to defend, a covenant of warranty to defend against reasonable third-party claims. So if that guy shows up, you have a duty to defend it. Okay, and then the last is this covenant of further assurances. It means you're going to do anything and everything necessary to ensure that the transaction happens. And finally, let's talk a little bit about the recording. I did mention this to you about recording, how important it is. Every state has a recording statute. Every state. In Indiana, we give that duty to the county recorder, the office of the county recorder. It's down on the 3rd floor of our county city building. In Michigan, we give that duty to the Register of Deeds. Every county has a Register of Deeds, and it is a central place for documents to be preserved so that we can research claims to title. And without the recorder's office, the title companies are worthless unless they keep their own title plan, and some do. Recording Act, everybody has it. What can you record? Deeds, land contracts, mortgages, anything that has to do with the land should be placed in a record somehow, unless it's a temporary document like a listing agreement or a purchase agreement. You don't need to put that of record, but you can. Leases, if you don't want to put the whole lease in there, do a memorandum of lease. I just collected, I'm doing a case right now that involves leased land and a sandwich thing where the owner of the land, we have a case where my guy has not been paid for his services. He filed a mechanics lien. Well, stacked on top of the ownership role is these leases, and so we had to find out who the leaseholders are so that we could name them in our complaint. To the record shows that getting that information from the recorder was essential. They tell the world at large what you're interested in the properties, and it gives the effective recording gives constructive notice. It's an important word to write down. It gives constructive notice to your prospective purchaser about the condition of title. Actual notice is if they see the deed itself or they see the property. Inquiry notice is if they ask you, do you own this property? But constructive notice is the whole purpose of the recording statute. The constructive notice will carry the day. If you do a transaction and something's not recorded and you have not had constructive or actual notice, the deal can fall apart and be returned. The deed record, in my view, the deed record should be sacrosanct. It should be biblical in its importance and religiously maintained and scrupulously administered and unabused because it's the only place you can go to find the truth these days. Okay, you got to have it. And believe me, you hear these ads on TV about or on the radio about how this, the mortgage fraud and deed fraud and taking your property. You hear that stuff all the time. It's true. It can happen. I've seen it happen. I've been involved in a case where a fraudulent deed was filed and my client lost her real estate by virtue of that. You got to be careful about the fraud. And so register. The county has a place where you can go register all of your properties and all of the deeds. All you do is put your name in, and they will search your name if there's a fraudulent transaction that they anticipate. And then that's it. That's about all I have to tell you. There's lots and lots and lots and lots more to tell you, but I would like to give you some time for questions. And I see that I have yammered on here for at least a long time. So I'll leave this open to questions. Those of you who want to unmute yourself and talk to me, that would be fine. And I can stay until my wife gets hungry, okay?
Yeah, this was great. I'm going to mute myself real briefly, but we have a small enough call that I think folks, feel free to use the chat window if you want to, but I think we're a small enough group here we can unmute ourselves. Bruce, that was spectacular. That's a lot of information in a short period of time and a lot of really interesting, useful information. So I will also shut up now and let other folks ask questions if they have them.
Hi, Bruce. This is your temporary wife, Barbara.
Yeah, I've already got one,
I don't know how you're going to handle it.
Well, I can't talk her into a sister wife. I've tried.
I would love to take your class that you have at IUSB.
That's it, yes.
Okay. Can you take it without like enrolling in the whole thing? Can you just take one class?
Well, here's what I would do, Barbara. You just kind of sneak in and sit down, and I won't ask you who you are, and you already know who I am,
Sounds like a winner to me.
Well, I try to avoid the administration if I can, and
Okay.
it's the class. There's two classes. L201 is the beginner class. It's the general case in law and business law. It's a business law. There's one portion of which is some of the stuff I've talked to you about today. Only it goes for 3 weeks rather than just 40 minutes.
Okay.
But you get all business law. You get torts. You get contracts. You get a lot of stuff in a relatively short period. The advanced class is something called L303. You might not want to take that as a first time. You have to be a junior to get in that class legitimately. Now you come on in because you look like a junior to me. You can come in and take the class.
Okay.
But it's complex, and it gets into real estate, deeper into real estate than my L203 class or L201 or 203 class. It gets pretty detailed and pretty deep into case law. We read a lot of case law in that. We don't read much case law in the early class, but we talk about it. So check the schedule at IU. I'm not sure if I'm back on the schedule for this coming semester. I haven't heard from them because enrollments are down these days. I've had a break, so I did not teach this past semester. I taught the semester before. But you would be welcome, and any of you listening, because it appears that all of you are listening, are welcome to come to the class. Just check the schedule and look for my name, because I'll let you sneak in for free of charge, except that if you bring a bag of cookies, I have to get one.
Well, I have a specific question that I want to talk to you off screen. What's the best way to reach you? Is it appointment or just give you a phone call?
Phone call is fine. If you keep me for 10 or 15 or 20 minutes, otherwise it's better to come on in. And I don't mind it. My office number is 574-234-3900.
Okay, thank you so much.
My office is over on Hickory Road. We are the first building north of Corby Street where it intersects with Hickory Road. Hickory Road is Logan Street extended. It runs on the west side of the town and country.
Okay.
And I guess we're the first office building past the Dollar General.
Okay. Is there a name out front of your building?
Yes, it says Botkin and Hall, BOTKIN and Hall. You can also get me, and you can all write this down if you want. You can get me at my email address, which is bhuntington, just like it sounds, just like the town, bhuntington @bhlawyers.net. Lawyers is plural, and BH is Botkin Hall, not Bruce Huntington. Okay. bhuntington@bhlawyers.net.
Okay.
And feel free to, if you feel an email. Now, mind you, I'll get your email. If you send it early in the morning, I might get to it by mid-afternoon. Okay, so just bear with me. I'm very, very, very busy at the moment, so feel free to call. If I don't answer you right away, just bear with me. I will get to you.
What days are your class and times?
Well, I don't know yet. They
haven't started.
They haven't set the schedule yet, so I would encourage you to take a look at the IUSB schedule and see if they mention me as a professor. The other guys won't let you sneak in.
Okay, definitely. Okay, thank you.
Bruce, oh, sorry, go ahead.
I know, I was going to say anybody. Go ahead. Go ahead, Marty.
So there was a question in the chat window. What is a lien, and what is the process for filing a lien?
Okay. Well, there are a couple of different kinds of liens. The most important lien that's available is my attorney's lien. If you don't pay me, I can come get you by liening up your property. That's the one I like the most. But there are mechanics liens. Your mortgage is a lien. Anything that constitutes an encumbrance on the property, a legal encumbrance, a mortgage, a mechanics lien, a judgment is a lien. If you have a judgment against you for some money that you didn't pay to somebody and they get a judgment, that constitutes a lien on your property. The lien is L-I-E-N, and it's nothing more than something that adversely affects the title of the property because that shows that there's a claim. And a mechanics lien is something where you have some work done or someone has some work done and they don't get paid or they're not happy, the mechanics lien will attach to the real estate until it's satisfied. And so if you are subject to a lien sometime, make sure you don't just pay the lien amount, that you get a release of lien as well, because the release of lien is critical to you as the owner. How do you place a lien on the property? You can simply, there are forms of lien. If you're a mechanic, you can go to the stationery store and you can buy a form of mechanic's lien. And it's simply, you simply identify who you are, who the property owner is, what you did on the property, when you did what you did on the property, because you have to bring your action to foreclose. You have to file your lien within 60 days for residential property if you're going to do something, with 90 days for commercial property. And it's an easy thing to do. But remember, all you're going to do is encumber the property. And you should file, if you do some work and you legitimately can hold a lien, you should do that.
Can you give an example of that, Bruce?
Sure. I had a case that came in here a while ago. We didn't know. We found this out in the title work. Some work had been done on this particular house. It was within the last several months. Work had been done, and it hadn't been paid for. A roof or whatever the mechanical work done, that it hadn't been paid for. The contractor, the mechanic, couldn't get paid, so he went and filed with the recorder, the county recorder, filed his mechanics lien. Remember, Statute of Frauds in writing when it relates to real estate. He filed his mechanics lien, and it's just a form that says, it's a sworn statement of notice intent to hold a mechanics lien, that you just simply file that lien document with the county recorder. They will accept it. And the thing of it is, if you have 3 or 4 lien holders, people who have filed the liens, they all take the same level. There's no priority in mechanics liens, because usually what happens is on liquidation of the property, you're simply paid off on a proportionate basis of what is owed. And so it's like bankruptcy sometimes when you do that. But filing a lien is a relatively simple process. And in fact, I think if you go to the recorder and you ask for a form of lien, they may give it to you, because they do have some forms that they will allow you to fill out.
Can you talk a little bit about the quiet title?
Sure. What is a quiet title action? A quiet title is where you have a confused title. There's some defect in title, something that hasn't been cleared up. You run into this sometimes where estates are not clear, or the estate hasn't been open. And I just today worked on this. In order to quiet the title of this transaction, I had my party had a buyer come to buy the house. The house was ready to sell. Everything was ready to go. But they discovered that the property was not owned by the widow who was selling it. It was owned by the husband who had died. Well, now the only way to remedy that is to quiet the title, meaning to remove the defective title. And we did that in this particular instance. We did that simply by filing an estate with the court, opening up an estate, if you will, and then naming my lady, who the widow, named her as the executor of the estate. The court opened up the estate, issued something called letters testamentary. And that was sufficient to take it to the title company and say she has the right as the surviving widow and as the named executor of the estate to convey the property, and did so. And the title company was pleased. We quieted the title in that way. Now there are other ways, Jeff, other reasons why you might have to quiet title. The one that seems most common is where you have this kind of situation just described to you, where there's something hanging out there that is problematic, and you use a quiet title action. And it's, these kinds of actions, Jeff, are a lot like sweaters. This one might be blue, and this one might be green, and this one might be red, but it's all the same idea in terms of the steps that are necessary to clean up the title.
And you discovered that during the title search, right?
Yes. Yes.
Thank you. Thank you for the answer. Title.
That's what it's all about. Again, I've been doing this. I've been doing this real estate stuff for 44 years, and I don't touch anything that doesn't show me a title. And if it's got defects, I can fix them. I can clean it up. We can do the things that are necessary to fix the issues that we're facing. But you don't ignore them, because you can't give good title where you have defective title or where you've taken defective title. And when if you give defective title to someone, they're going to come back to you on that deed and say, hey, fix this. And that's, again, why you never accept a quitclaim deed. Okay, never. Don't do it.
What would be the purpose that a quitclaim deed exists then?
Well, quitclaim deeds, let's say Barbara and I don't do well together, okay? I snore and she doesn't like that fact, okay? Or I don't like her cooking, there's just some reason Barbara and I are just not gonna make it, okay? And she decides that she's not gonna put up with me anymore, and she goes down to the judge and says, get me free of this guy, and she divorces me, okay? And the judge says, you gotta give her the real estate. Well, we're already together in title to the real estate, right? She and I own husband and wife, right? I can give her a quitclaim deed that relinquishes all of my right, title, and interest in that marital property. Okay, and that's when I have no qualms about it. When you're given that property in that kind of situation, if you have good property to give to a family member, you can do it with a quitclaim deed. But again, remember, the title that you get is the title that you give. That's what you have. And so warranty deed, no matter the circumstances, is a better way to go.
Okay, thank you.
Can you go
Cheryl,
over?
Wait, here we go. Who's next?
Go ahead.
Antonio, wait a minute. Either one, Cheryl or Antonio. Go
I'm going to jump in. I think Cheryl, I'm going to let Antonio go first, and Cheryl, you'll go next. Okay.
Okay.
We'll get to
I
you.
was just going to ask, yeah, can you go over the seller financing again and what the proper procedures would be to go about that in the proper way?
Sure. First of all, completely avoid land contracts.
I'm in a meeting. I won't be done until 9:15.
Okay, Cheryl. Hang on a minute, Antonio. Okay.
Sorry about that. Yes, I muted her. Go ahead.
Okay. Tell me the issue again. Here, the interruption.
It was about seller financing.
Seller
and
financing, sure.
Yep.
It's a simple transaction, Antonio. It's a purchase money mortgage. Is that you identify in the contract that this is going to be subject to seller financing, and instead of a land contract, you simply use a note, promissory note, and a mortgage. You record the mortgage itself, and it's a mortgage form. It just says on mortgage, and it's you see them everywhere. You can get a mortgage form at any stationery store. Make sure that it does what you want it to do in terms of securing the transaction. See, a mortgage is a document that we use to perfect a security interest in the property. We have the two documents that we use is the promissory note and the mortgage. The promissory note is a promise to pay the debt that is shown on the promissory note. Let's say we buy a house for $100,000. We put $20,000 down and we seller finance $80,000. That promissory note for $80,000 is an enforceable document. But we're going to take a security interest in the real estate. We're going to say my collateral is the real estate, and the mortgage is the document, the security document that shows that you have a collateral interest in that property. And that's why you simply do it. It's not complicated at all. It's very simple to do. The promissory note does one thing, the mortgage does another thing. And if you have to foreclose, for instance, non-payment, you got to foreclose, you simply file an action in foreclosure in the Superior Court, and it goes to the judge, and your foreclosure happens. But what you are foreclosing is the promissory note. They didn't pay the promissory note. You foreclose the promissory note by virtue of your interest in the property established by the mortgage, the security interest in the property established by the mortgage. It's done a million times a day in this country when transactions happen, where properties are purchased and financed. And it's easy to do, and it's a much, much better way because you eliminate all the nonsense that attaches to a land contract. You know, people do land contracts because often they have no credit or they have no down payment or anything like that. So what? You can do that with a purchase money mortgage as well. You can finance the whole thing, but you should do it as a purchase money mortgage so that you have you establish a security interest in the property. And the Skenzel case issues that I talked about with regard to the foreclosure or forfeiture, there's no forfeiture in a mortgage, it's foreclosure. And these days the courts look at land contracts and require you to foreclose anyways. So save the steps necessary that you would have to go through, simply do a purchase money mortgage, and you essentially become a banker, a private lender. And it's
Okay, thank you.
okay. Cheryl, you had a question. I think, is Cheryl muted?
I can unmute her. Hold on. Cheryl, I'm going to unmute you and you can ask your question. Sorry about that. It turns out I cannot unmute Cheryl. I can only ask her to unmute. So I'm asked.
Oh, Cheryl, you there? There we go.
There she
Hi,
goes.
I just wanted to make two comments. One had to do with quick deeds. I worked at the library in the reference department, and we were always getting people coming in for quick deeds. And I'm going to be honest, some of it had to do with, for instance, they were trying to transfer property really quick so that the welfare department could not attach the property. They were trying to do quick claim deeds because there was like a lawsuit against whoever owned the property. But when you were talking about quick claim deed, it was very, and you would hear them talking about it. And as if we didn't exist, that they were trying to, I would use the word defraud an agency or something. The other thing I was going to mention is that the public library has a database that has Indiana legal forms. And within those forms are all kind of things like leases, landlord leases, selling house, real estate thing. And they've all been prepared by lawyers. And then it's a database the library covers, and all you pay for is, no, you don't even pay for the printing anymore if it's more than $5. Might save some people if they just wanted to look at something without having to buy.
Sure. Well, I have a couple of comments there, Cheryl. One is with regard to quitclaim deed, they are often used for fraudulent purposes and to try to evade something, to do something quickly. It is not a quick claim deed, it is a quit, Q-U-I-T claim deed.
Mm-hmm.
Okay, that's when you're giving up. And so they are ripe with fraud. And I got to tell you, any transaction involves a deed like that for those purposes is facially, on its face, ab initio, a fraudulent deed. Okay, so you be very careful with that. The other thing I would say is you have a book on your shelf with all those forms in it. I have a book on my shelf called Gray's Anatomy that shows what happens when you do an appendectomy, and I can promise you I'm not going to do my own. Okay, I would encourage you to be careful about using forms. You can use them, and I think Cheryl's offer and notice to everyone that those forms are out there. I just caution you, be careful. Make sure that
No, I was saying if someone, for instance, didn't want to go out to buy forms to get an idea what's in them, and then this is a good way to, I mean, you really shouldn't use the forms you get at Staples, to be quite honest.
Yeah.
And but what we would tell people, if you want to see quickly what's in it without going to buy the forms at Staples, then you can look at this database, which are forms that are updated on a regular basis. And it's a very expensive database, but it's a good way to see what's in the forms. So when you go talk to the lawyer, you have an idea what terminology is, etc.
What's the name of that book?
It's not a book.
Oh, okay.
It's an online database.
Okay. And what do you
That,
call that database? Is there a name for that database?
I don't remember, but if you were to call the main library at 282-4646 and ask them about the database that has legal forms, they'll tell you how to get to it, and you can access it from home if you have a library card. And like I said, we used to recommend to people when they come in, well, look at this, and then when you go see a lawyer, you have an idea.
Okay.
You know what I mean?
Sure.
What to talk to him about.
Yeah, having your questions in hand and a little pre-knowledge is always a good thing to do. Yeah, I agree.
And Cheryl, that's good. In fact, I'll go ahead and see if I can find the name of that database, and I can include it in my next email to the group as a reference, because it does sound like it could be useful, especially if you are planning a meeting with the lawyer, to review some of those documents in advance so that you use your time wisely.
I suppose my last bit of advice is the advice my father gave me many years ago is try to avoid lawyers. If you can avoid dealing with a lawyer, you should. Okay. I tell people lawyers are luxuries. You know, we serve a purpose. I candidly, I'm so busy right now. I'm not turning clients down, but I'm very careful about who I'm taking at any given time. And it's throughout the firm here. If any of you don't want to come along and practice law, come on over. I got a job for you. We could use the help. Be safe. If I have any closing documents or any closing statements to make, my closing statement would be careful. You're making investments in things that last, and the circumstances that you enter into a transaction with can help you or hurt you. And just, you know, if you think it's too soon to call a lawyer, you might already be in trouble. So for a couple $100 to get things laid out ahead of time, I think that's the best way to go. And if I know who you are, like my students, for example, I get calls from students pretty regularly about what to do. And in one case just recently, I formed a company for this guy because he needed help putting it together. And he says, I can't afford to pay you right now. Can I pay you later? I said, I'll tell you what. The guy had a power washing business on the side. I said, go power wash my house. It's a deal. Done. Okay. I have been known to give up legal services for cookies. You can only, Barbara, you can only
cute.
chocolates for cookies.
That's great. That's great.
Paula has been down here smiling at me the whole time, but
That's because I'm going to bring you a batch of cookies, okay?
All right.
I just want to say I really appreciate listening to you. Everything you said in the last 2 years, what I've been going through, as far as getting back to my house when I was married for 16 years, but total being with him 28 years, I've learned a lot. And everything you said, that's majority of it I've read and stayed up countless nights. And everything worked out for the better for me. That's what I can say, because we had things set up from the beginning, and a lot of times people don't know anything until you do a title search. That's where your magic come in. What you said, you have to be able to do that, and then come to me to say, okay, and then you pick and choose, not take somebody's case and then get in and say, oh, okay, and then hoping that I didn't find out. You know, because I did the right thing by opening up a state for all the other kids and my two. But lo and behold, of course, I knew what I knew, but I tried to be fair. But so everything you said, I would love to take your class. I've learned that. I don't know the codes to it, but I tell you, I'm a strong believer in what God can do. And he opened up the windows of heaven for me. And I really, really appreciate you with everything you said. And I'm telling you, I've read almost verbatim what you said for 2 years, countless nights up reading. So I really do appreciate you, and I will be taking that class.
Well, you know, you could have spent all that time in law school. Come come out with a degree for all the reading you did.
Yes, sir.
I run into a lot of issues that are related to marriages and ex-marriages and things like that. And
Mhm.
the former Mrs. and I parted in 1998, and I was a bachelor for 20 years, and I took the position that marriage is a great institution, and for
Yes.
people who need to be in an institution, marriage is probably as good as any.
Oh yeah. Oh yeah. Oh yeah. Yes, it's beautiful. I will advise anybody because it shows you who you really are, and it makes you dig deeper. And I've learned a lot anyway, way before my beloved passed. And I'm telling you, marriage is a great thing because it pulls from you and it reshapes you as a person if you let it. So yes.
Well, yeah,
I agree.
what I've learned, I remarried 6 years ago, and what I've learned is the concept of obedience.
Yes.
And, yeah, sit, stay,
Put up-
roll over, all of
Yes.
that.
Yes.
In the chat, I put up the place you go at the library, and all the databases are listed on one page.
Oh, okay,
When you scroll down, you'll see 2 different sources for legal information.
okay.
And as I said, we often encourage people, look at those, and then when you go to the lawyer, you can sometimes even say, oh, I like what it says in this part of this form, particularly with wills. And, we kind of point out, pick what you like, show it to the lawyer.
Yeah, be careful of wills.
Yeah.
Tell me about it.
The whole
Thank you, Cheryl, for posting that. It's in the chat window for anybody who's looking for it, but thank you, Cheryl.
Yeah, remember
Actually, Bruce, Cheryl brought up a thing that I wanted to ask and I have forgot. Do you do trust?
Yes, a simple trust I'll do. I leave the complex tax-related kinds of things to people who know what they're doing. But if you need a simple will and a simple trust, yes.
Like a family trust for property.
Yeah, that's simple. That's easy enough to do. Yeah. See, you got to remember the purpose of a will or a trust is to do what? It's to hold and convey your real estate,
Yes. Mhm.
your property, and mostly real estate.
Yes.
What kind of cookies, Paula?
Yeah.
That'll be a surprise. Chocolate chip.
Oh, deal.
Okay.
We're gonna have this contest between you, Paula, and Barbara.
Yeah. Look, Paula, you stole my chocolate chips. Now I got to figure out something else.
Oh no, don't feel bad about
Oh, you
it.
like the chocolate chips? we have a different version of the chocolate chip.
What I want to do is encourage you to call me. Okay.
Okay.
If you got a question, call me. I promise I will answer you. Any of you who are hearing this tonight, feel free to call. Say I was on listening, because all of you are listening. None of you are talking. Very few of you, but feel free to identify who you are and ask a question about what we talked about tonight, and I'm pleased to answer that. If you keep me on, a short time, if you keep me on there, come on in here, sign on, and you can be my new client.
Yeah, I think that's what I would like to do.
Well, have fun. Go be brave. Take a chance. Go do it.
Yeah. I have some different things I'm getting ready to be involved in that I definitely need legal advice.
Okay. I'll try.
I hate to interrupt, so people do have more questions, but I will point out it is 8 o'clock, and we've done a really good job on the series to stick to our time frame and to respect everyone's time, including Bruce's time. And this is probably the most informative session we've had, really, in terms of the detail of knowledge. It's really been fabulous. Bruce, I'll read you one more comment from the chat window from Aaron Green, who had to sign off about 10 minutes ago or 15 minutes ago. He said, "This was amazing. Thanks for this info. Much love to Bruce."
Oh, there it is. Yeah.
So that was a nice comment in the chat window. This was really a lot of valuable information. It's remarkable how much there is, and
there's lots and lots more. I've spent my career in banking and finance and mortgage finance. I was a developer. I developed subdivisions and commercial stuff. I did real estate investment trusts, walking around New York selling to those New York brokerage houses. And so I've touched it one way or another. So as you grow, as you grow, keep growing, you know.
Yeah.
And I want to advise you about this. Remember, there's one guy in the world who's lost more money than most of us will ever make in the real estate business, and that's our good friend Donald Trump. Bear in mind, he's lost a lot of money in this business too.
And so before we go, I want to pitch next month's session because it does relate to what some of the things that Bruce was mentioning tonight, and that is on building codes and zoning. So again, zoning relates to Bruce's comment. You got to know what you're buying. You can't just buy a property and assume you can do anything you want on it. It may be zoned for a certain type of use, which may limit what you are allowed to do on that property. So next month we'll have our building commissioner, Randy James, and Angela Smith, who's our zoning guru for the city, speaking about those issues. And so what to watch out for, what to be aware of when it comes to purchasing a property and the relationships between that property and the uses allowed on that property.
Well, thank you for being my crowd tonight. I appreciate it. I enjoy the opportunity to preach a little bit.
Yeah, Bruce, this was great. I'll be following up with you with a very hearty thank you.
Cookies, Marty, cookies.
Yeah. Okay, well, that was a little stretch for me, but I'll try.
Well, I can, you know, you can buy them. They don't have to be necessarily homemade. All right, thank you very much.
Yeah.
Thank you.
Yeah. Thank you, everyone. We'll see you
Yeah,
next
have a
month.
good evening, everyone.
Thank you. Have a good evening.
Bye.
All right. Goodbye. Good night.